This is a domestic violence case, and the case is K.T. versus E.S. It's located on slide number 76. The decision concerns children being named as protected parties in a restraining order. On May 30th, 2023, mom files a request for a restraining order against father. In her request, mom asks that the party's 3 children be named as other protected parties. Mom also requests sole legal and physical custody. In her declaration, mom describes extensive physical and sexual abuse. And for the purpose of this presentation, I'm not going to get into all the incidents, but if you read the decision, it's quite graphic. But here's an example. Mom alleges that on June 13th, 2022, while the father was driving, he hit mom in the face and slammed her head against the car's middle console. And while this is happening, the children are in the car and they're yelling at him to stop. On another occasion, while mom is lying in bed next to the children, father enters the room and severely beats her with a belt buckle. When the children wake up, he tells them to go back to sleep. Then he forces himself sexually on mom while the 2 kids were in the same room, in the same bed. Mom calls the police, and she's transported to the hospital. And when she's released from the hospital, she decides to get away from him. So she moves from California to Texas, where she obtains a restraining order against the father. On 12/24/2022, mom allows the children to spend part of the holiday with the father. But instead of returning the kids to her on the day that they agreed, he abducts them. What he does is he takes them from Texas to Mexico, stays there for a little bit, and then goes to California. And he finally responds to mom's requests, multiple requests, to see the kids. And he says you could see them only if you return to California and reconcile with it. Based on the alleged facts, the trial court grants mom a temporary restraining order because she files a petition and she gets an immediate temporary restraining order, but does not indicate the children as protected parties. The judge writes on the TRO request that there was no showing of imminent risk of harm to the children. At the hearing for the permanent restraining order, mom's attorney attempts to elicit testimony about some of the events that the children were present for, at which time the judge interjects. I recognize that you're getting into child custody issues here, counsel, but this doesn't seem to be directly related to the domestic violence restraining order at issue, and then makes the attorney move on without any further questioning. Under cross-examination, mom explains that since father's abduction of the children, she begged him to return to them. And she says, I haven't seen my kids for 7 months. When it's father's turn to testify, he doesn't. He's advised of his Fifth Amendment rights, and he declines to testify. At the conclusion of the hearing, the judge grants mom's request for the restraining order, but denies to add the children as protected parties. The judge notes, I do take your point that abuse has occurred in front of the children and is certainly very traumatic to the kids, and it should not occur. However, there has been no credible evidence, at least in front of this court, regarding any physical or sexual abuse that has been sustained by the children in this case. The trial court then awards joint legal custody and temporary physical custody of the children to mom and does not name them as protected party in the restraining orders. Well, mom appeals, and of course, the trial court's affirmed in part and reversed in part. In the reversing the decision, the Court of Appeal notes that good cause is what's necessary for the determination as to whether or not children should be protected parties. And in this case, the court was making the burden be that they had to be victim to physical abuse. And that's not the standard. The court then on stated that what's important here is that if children witness domestic violence just one time, that may and probably will be enough to name them as protected parties and include them within the restraining order. And of course, in this case, they witnessed multiple occasions, and so the trial court was way off. So this is a really important case for us family law attorneys, because I can tell you that there's a lot of cases that we've had where the courts have denied children as protected parties. And of course, this will be a case that you'll see me citing in court quite a bit.